Good day, everyone. Welcome again to the Basic Philippine Law and Jurisprudence channel. We are again on the series of lectures on civil procedure. Our topic for today is pleadings. Okay. What is pleading? Pleading is defined as the written statement of the claims and defenses of the parties submitted to the court for appropriate judgment. It is a paper, okay, containing the basic allegations of the claims in the complaint as well as the defenses in the answer, which is submitted to the court for its consideration. Now, what are the basic pleadings that are allowed? Okay. The basic pleadings are, of course, the complaint, the initiatory pleading of the complaint or petition, the answer, containing the counterclaim, cross-claim, a third or fourth party complaint, and the complaint in intervention. Okay. An answer may be responded to using a reply only if the defendant party attaches an actionable document to the answer. So unlike the previous rules, wherein a reply may be filed whether or not the answer contains an actionable document, the new rules require that for you to be able to file a reply, the answer to which you are replying must contain an actionable document. Now, what is a complaint? A complaint is the very first pleading that you file in court. It is a pleading containing the allegations of the plaintiff's claims or causes of action, the names and residences of the plaintiff and the defendant. Okay. What is an answer? An answer is an initial responsive pleading. Okay, it is a pleading in which a defending party sets forth his defenses. Okay. What is the purpose of pleading? It is to notify the parties of the claims or defenses that each has against the other. It is also to inform the court of the respective parties' claims and defenses. In other words, to a case, there are two sides of the coin. There are two versions of stories. Okay, one is the version of the plaintiff, and the other is the version of the defendant. Now, these stories, claims, or defenses are all contained in the pleadings of the parties. What is a third-party complaint? It is a claim that a defending party may, with leave of court, file against a person who is not a party to the action, called the third or fourth party defendant for contribution, indemnity, subrogation, or any other relief. So initially, in the original action, there are two parties. The plaintiff, the one who filed the action, and the defendant, okay, the one who is responding to the claims of the plaintiff. Now, if the defendant, for example, has a claim against a person who is not a party to the action, the defendant can file a third-party complaint to drag or bring in that person as a party to the action. He will be called now a third-party defendant. Okay. While the original defendant in the main case will be called the third-party plaintiff. Okay, what is the purpose? Why would you bring in a person who is not an original party to the action? Because the defendant wants to, the original defendant wants to claim contribution, indemnity, or subrogation from the third-party defendant. We also have what we call a complaint in intervention. Okay, a proceeding in a suit or action by which a third person is permitted by the court to make himself a party, either joining plaintiff in claiming what is sought by the complaint or uniting with the defendant in resisting the claims of the plaintiff. So if, for example, there is a case, okay, and you are not a party to that case. But you want to intervene because you have an interest to protect. Okay. Can you by yourself make yourself a party to the action? Yes, by filing a complaint in intervention. Either you join the plaintiff or you join the defendant. Okay? Um, in filing a complaint in intervention, such person becomes a party to the action for the protection of some right or interest alleged by him to be affected by the proceedings. Okay, we now go to the matters which are alleged in the answer. What are the matters which must be set up in the answer? Of course, you have to allege in your answer the defenses. Now, there are two kinds of defenses, a negative defense and an affirmative defense. What is a negative defense? It is a specific denial of the material facts alleged in the pleading, essential to her cause of action. Okay, so specific denial of the material facts alleged in the pleading. Now, what would make a denial specific? We will discuss that later, but it's sufficient it is to state right now that a negative defense is one in which the defendant sets up a specific denial of the material facts alleged in the complaint. On the other hand, an affirmative defense is an allegation of a new matter, which, even hypothetically admitting the material allegations in the complaint, it would nevertheless prevent or bar recovery by him. The affirmative defense includes fraud, statute of limitations, release, payment illegality, statute of frauds, estoppel, former recovery, discharge in bankruptcy, and any other matter by way of compensation and avoidance. So in other words, like for example, in a suit for collection of some money, okay, so a classic example of an affirmative defense is payment. So you are admitting that you are indebted, that there was a loan that was given in your favor. But you have an affirmative defense that that loan was already discharged because you have already paid the amount of the loan. So that is an affirmative defense. Okay. Affirmative defenses may also include grounds for the dismissal of a complaint, such as lack of jurisdiction over the subject matter, that there is another action pending between the same parties for the same cause, and that the action is barred by prior judgment. So these instances may also be raised as an affirmative defense in the answer. Lack of jurisdiction over the subject matter, litis pendentia, and res judicata. Another, aside from defenses, you can also set up in your answer the counterclaims. A counterclaim is any claim which a defending party may have against the opposing party. A counterclaim may either be compulsory or permissive. What is a compulsory counterclaim? It is one which arises out of or is connected with a transaction or occurrence constituting the subject matter of the opposing party's claim and does not require for its adjudication the presence of third parties with whom the court cannot acquire jurisdiction. A compulsory counterclaim not raised in the same action is barred unless otherwise allowed by these rules. You can also set up in your answer a cross-claim. What is a cross-claim? It is any claim by one party against a co-party arising out of the transaction or occurrence. A cross-claim is any claim by one party against a co-party arising out of the transaction that is the subject matter of either the original action or of a counterclaim therein. So if, for example, you are a defendant in a case, Okay, and you have a claim against your co-defendant, you may set it up as a cross-claim in your answer. Counterclaims and counter-cross-claim. A counterclaim may be asserted against an original counterclaimant. A cross-claim may also be filed against an original cross-claim. What is a negative defense? Okay, a negative defense is a specific denial of the material facts alleged in the pleading. The denial must be specific and must specify the material allegations that is not admitted and sets forth what he claims to be the facts. So the mere fact that you are denying the allegations in the complaint will not be sufficient. You must state the specific facts under which you are denying the allegations in the complaint. There are two types of specific denials. First is the absolute denial, done by specifically denying the material allegations and setting forth the matters relied upon to support his denial. Partial denial, it does not make a total denial, but specifically denies only part of the averment. He shall specify the portion of the allegations admitted and deny the remainder, setting forth what he claims to be the facts. There is also a denial by disavowal of knowledge, specific denial of immaterial averment on the basis that he does not have knowledge or information sufficient to form a belief as to the truth thereof, and denial of actionable document. It requires more than just a specific denial. It must be under oath. Now, the types of specific denial, under the types of specific denial, we have what is so-called a negative pregnant. What is a negative pregnant? It is an allegation which is stated in the negative form, so you're denying it, but it implies an admission of its affirmative. That is why it is called a negative pregnant. It is negative, meaning you're denying it, but it is pregnant with an admission. So coupled with an implied admission. It does not qualify as a specific denial and is considered to be an admission since it denies only the qualified portion but not the main or totality of the allegation. It is a denial pregnant with an admission of the substantial facts alleged in the plea. Okay, we have the case of Mahilum versus Ilan. So in this case, this is a case involving or explaining to us what is meant by negative pregnant. Okay. The above allegations in the pleadings are revealing. It was the petitioner herself who appeared and signed the agreement of deed of sale in question. They should have categorically alleged that they bought the property from the petitioner herself, and if indeed this was so, their ambiguous allegations constitute a negative pregnant, which is an admission. This particular denial had the earmark of what is called as a negative pregnant. That is a denial pregnant with the admission of substantial fact. Because in this case, they should not have referred to the seller as another person named as John Doe, whose identity is yet to be established, who introduced herself as Ruby Serrano, or the person who introduced herself as Ruby Serrano. Where a fact is alleged with qualifying or modifying language, and the words of the allegation as so qualified or modified are literally denied, it has been held that the qualifying circumstances alone are denied while the fact itself is admitted. A denial in the form of a negative pregnant is an ambiguous pleading since it cannot be ascertained whether it is the fact or only the qualification that is intended to be denied. Next case, Benson versus Rural Bank of Buena Vista. In this case, respondent did not deny being the issuer of the official receipt. It averred that petitioner's payment was false and self-serving, but without necessarily admitting that payment was made. The same cannot be considered as redemption price. By making such an ambiguous allegation in its answer, respondent is deemed to have admitted receiving the amount of 6,000. If an allegation is not specifically denied, then the denial is a negative pregnant. The allegation is admitted. A denial in the form of negative pregnant is an ambiguous pleading since it cannot be determined whether it is the fact or only the qualification that is intended to be denied. Respondent failed to refute petitioner's claim of having paid the amount of 6,000 pesos. We also have the case of Caneland Sugar versus Alon. Petitioner does not dispute its loan obligation. Petitioner is of the contention before the RTC that the promissory notes are silent as to whether they were covered by the mortgage trust indenture and mortgage participation. It does not categorically deny that these promissory notes are covered by security documents. These vague assertions are in fact negative premises. Where a fact is alleged with qualifying or modifying language, and the words of the allegation as so qualified or modified are literally denied, it has been held that the qualifying circumstances alone are denied while the fact itself is admitted. Okay, let us go to affirmative defenses. What is an affirmative defense? It is an allegation of a new matter which, while hypothetically admitting the material allegations in the pleading, it would nevertheless prevent or bar recovery. Okay, so if the other one is a negative defense, meaning you're specifically denying the allegations in the pleading, in affirmative defense, you're admitting it. But even though you're admitting it, okay, there are new matters which would prevent or bar the recovery of the plaintiff. What are the kinds of affirmative defenses? We have fraud, statute of limitations, release, payment, illegality, statute of frauds, estoppel, former recovery, discharge in bankruptcy. Court has no jurisdiction over the person of the defendant, improper venue, plaintiff has no legal capacity to sue, pleading states no cause of action, condition precedent for filing was not complied, lack of jurisdiction over the subject matter, litis pendentia, and res judicata. So for the defenses covered by A to J, the court may conduct a summary hearing, while for the defenses covered by K to R, the court may motu proprio without any motion, resolve the same after filing of the answer. Okay, the counterclaims are of different kinds. They are of two kinds. Compulsory counterclaim. So after the defenses, whether negative or affirmative, the answer can also contain the counterclaims. The counterclaims in effect serve also as a form of a complaint. So even though it is contained in the answer is in itself a complaint because it contains counterclaims. So what are the kinds of counterclaims? Compulsory counterclaim is one which arises out of or is connected with a transaction constituting the subject matter of the opposing party's claim and does not require for its adjudication the presence of third parties of whom the court cannot acquire jurisdiction. On the other hand, permissive counterclaim is one in which the defendant may or may not claim in the same action. If the plaintiff fails to file an answer to the permissive counterclaim, he may be declared in default. Okay. Cross-claim is a claim by which by a party against a co-party, arising out of the transaction that is the subject matter either of the original action or a counterclaim therein. Okay, we now go to the case of Calibre versus Sebastian. Okay, Calibre was one of Bayer Pills distributors of chemicals. However, Bayer Pills stopped delivering stocks to Calibre after the latter failed to pay its unpaid accounts. Now, accusing Bayer Pill of maliciously breaching the distributorship agreement, Calibre filed a suit for damages. Calibre raised the issue that the counterclaim against them is in its answer with counterclaim. Bayer Pill denied Calibre's allegations and prayed for the collection of a certain amount from the date of default as provided in the dealership agreement. Calibre raised the issue that the counterclaim against them is permissive. And since Bayerfield failed to pay the docket fees, the court acquired no jurisdiction. So remember that this is a suit for damages filed by Calibre against Bayerfield because Bayerfield did not continue with delivering the goods, okay, under their dealership agreement. Now, in its answer, okay, Bayerfield raised as a counterclaim the unpaid amount of Calibre under the distributorship agreement. Calibre raised the issue that it is a permissive counterclaim because it did not arise of the main cause of action, which is one for damages. The Supreme Court said that Bayerfield's counterclaim was compulsory, hence it need not pay the docket fees. It noted that it arose out of the same dealership agreement. That was the trial court's ruling. However, the Supreme Court ruled that Bayerfield's counterclaim is permissive, but the trial court should have given it the opportunity to pay the docket fees. To determine, in the case of Calibre, the Supreme Court laid down the test to determine whether a counterclaim is compulsory or permissive. Okay, are the issues of fact or law raised by the claim and the counterclaims largely the same? Would res judicata bar a subsequent suit on defendant's claim or refute plaintiff's claim as well as defendant's counterclaim? Is there any logical relation between the claim and the counterclaim such that the conduct of separate trials would entail a substantial duplication of effort and time by the parties and the court? The fourth test is the compelling test of compulsoriness. Bayerfield's suit may independently proceed in a separate action. The causes of action they filed against each other are distinct and do not involve the same factual issues. The counterclaim for collection of money is not intertwined with or contingent on Calibre's own claim for damages, which was based on the principle of abuse of rights. Both actions involve the presentation of different pieces of evidence. Calibre's suit had to present evidence of malicious intent, while Bayerfield's objective was to prove non-payment of purchases. In other words, they are different. They did not arise or they are not connected or intertwined with Calibre's suit for claim of damages for breaching the distributorship agreement. Okay, so we have the case of Ong versus Enrile. So this is a case involving damages, okay, which was filed by Enrile against Ong. Ong, in his answer, pleaded that the suit is a malicious prosecution and claimed damages. Respondent filed a motion to dismiss, which argued that the petitioner's counterclaims are actually permissive. A counterclaim is permissive if it does not arise of or is not necessarily connected with the subject matter of the opposing claims. It is essentially an independent claim that may be filed separately in another case. On the other hand, permissive counterclaims require payment of docket fees, while compulsory counterclaims do not. There are tests which were laid down to determine whether or not a counterclaim is compulsory or is it permissive. The following questions should be asked. Are the issues of fact and law raised by the claim and the counterclaim largely the same? Would res judicata bar a subsequent suit on defendant's claims absent the compulsory counterclaim rule? Will substantially the same evidence support or refute plaintiff's claim as well as the defendant's counterclaim? Is there any logical relation between the claim and the counterclaim? A positive answer to all four questions would indicate that the counterclaim is compulsory. A counterclaim purely for damages and attorney's fees by reason of the unfounded suit filed by the respondent has long been settled as falling under the classification of compulsory counterclaim, and it must be pleaded in the same action, otherwise it is void. Okay, so there is a suit for malicious prosecution and claimed damages. Now, the civil complaint for damages which was filed against Ong, okay, and the counterclaim of Ong that it is malicious prosecution and the damages that he is claiming as a result of the malicious prosecution is a counterclaim which is compulsory. Okay, and it must be pleaded in the same action, otherwise it is barred. We have the case of Torres versus Court of Appeals. So in this case, Shera sold a parcel of land to Chibi, representing to her that there was no patent issued to the said land. Chibi, on the other hand, sold her rights to Laico with the stipulation that if Chibi fails to secure the transfer of title to the Laicos, she would return them twice the amount of the purchase price. Now, Laicos discovered and Chibi learned that a free patent has previously been issued to Shera. Shera's filed a complaint against Chibi and the Laicos, praying that he be allowed to repurchase the land under the provisions of the Public Land Act. Laicos filed a cross-claim against Chibi for collection of twice the amount of the price. So Sheras and Laicos entered into a compromise to amicably settle the case as between themselves, provided that Laicos would pursue their claim against the Chibis. Now, could the cross-claim stand after the complaint in the same action was dismissed with prejudice? A cross bill, strictly speaking, is one brought by a defendant against other defendants in the same suit, touching the matters in question in the original bill. It is considered as an auxiliary bill, dependent upon the original bill, and can be sustained only on matters growing out of the original bill. So in this case, the cross-claim was purely defensive. It arose entirely out of the complaint and could prosper only if the plaintiff succeeded. Hence, it could not be the subject of an independent adjudication once it lost the nexus upon which its life depended. So it cannot stand without the original complaint. So the dismissal of the cross-claim should have followed the dismissal of the complaint as a matter of course. Okay. Now, let us go to reply. What is a reply? As previously discussed, a reply is a pleading which is filed, okay, to answer the or react to the actionable documents pleaded in the answer. All new matters alleged in the answer are deemed controverted And if one wishes to interpose any claim arising out of the new matters, such claim shall be set forth in an amended or supplemental complaint. However, the plaintiff may file a reply only if the defending party attaches an actionable document to his answer. A reply is a pleading, the function of which is to deny or allege facts in denial or avoidance of new matters alleged in or relating to the said actionable document. In the event of an actionable document attached to the reply, the defendant may file a rejoinder if the same is based solely on an actionable document. So, the only function of a reply is to deny or to allege facts in denial or avoidance of new matters relating to actionable documents alleged in the answer. Now, if in the reply there is also an actionable document alleged to or attached thereto, then the opposing party can deny it using a rejoinder. Okay, you must remember that reply is allowed only if an actionable document is alleged in the answer. The general rule is that the reply is a prohibited pleading because all new matters alleged in the answer are deemed controverted. However, if there is an actionable document attached to the answer, reply is allowed only for the purpose and limited to the denial of new matters alleged or relating to actionable documents appended in the answer. If the plaintiff intends to interpose claims arising from the new matters alleged, he may file an amended or supplemental complaint, regardless of whether the defendant has or has not attached an actionable document in the answer. What is a rejoinder? It is a pleading filed in response to the reply. It may be filed only if there is an actionable document attached to the reply. Its function is limited only to denying the actionable document attached to the reply. Now let us go to third-party complaints. What is a third-party complaint? It is a claim that a defending party may, with leave of court, file against a person not a party to the action for contribution, indemnity, subrogation, or any other relief in respect to his opponent's claim. You must remember that with respect to filing of third-party complaints, it is always with leave of court. You ask permission from the court. Why? Because you are bringing in a person who is not a party to the action. Okay, why are you bringing him in? Because you have a claim against him. So the defendant now becomes a plaintiff relative to the third party defendant. Okay. Bringing of new parties. Okay, when the presence of parties other than those to the original action is required for the granting of complete relief in the determination of a counterclaim or cross-claim, the court shall order them to be brought in as defendants if jurisdiction over them can be obtained. A third-party defendant may allege in his answer or defenses, counterclaims or cross-claims, such defenses that the third-party plaintiff may have against the original plaintiff's claim. He or she may also assert a counterclaim against the original plaintiff in respect of the latter's claim against the third-party plaintiff. Okay, the purpose of third-party complaint is to adjudicate in the same case all matters related to the controversy. Okay, in order to avoid multiplicity of suits. We have the case of DBP versus NLRC. So in this case, private respondents were hired as security guards by CISCOR. They were hired for the purpose of securing the premises of DBP. However, the respondents resigned Now, for failure of CISCOR to grant their claims, they filed against CISCOR before the NLRC. Recovery of certain benefits such as 13th month pay, service incentive leave. Now, CISCOR filed a motion to implead DBP and averred that under the labor code, they are jointly and severally liable to pay their salaries. What we actually have here is a third-party complaint. Third-party complaint filed by CISCOR against DBP. Okay. For contribution, indemnity, subrogation. Whenever practicable and convenient, the securities agencies in pleading the bank for indemnity and subrogation, considering that the complainants work with the bank to safeguard the premises, property such as a third-party complaint would therefore be proper. That the bank has not disputed liability but professes merely subsidiary instead of solidary liability. Okay. Now we go to the parts and contents of a pleading under Rule 7. Okay. Of course, a pleading, the first portion that you will see in the pleading is the caption. It sets forth the name of the court, the title of the action, and the docket number assigned. Okay. The title of the action indicates the name of the parties. Okay. Their respective participations, either as plaintiff or as defendant, will be indicated. Okay. Second, we go to the body of the pleading. It sets forth the allegations of the parties, the claims or defenses, the reliefs prayed for, and the date of the pleading. Now, the body of the pleading is divided into several paragraphs. Okay, the statement in the body of the pleading shall be divided into paragraphs so numbered to be readily identified, each of which shall contain a statement of a single set of circumstances so far as that can be done with convenience. It is numbered for purposes of identification so that the one responding can easily refer to the paragraph which is being responded to. Okay, the headings. When two or more causes of action are joined, the statement of the first shall be prefaced by the words first cause of action, of the second by second cause of action. If there is an answer, it should also be divided in such a way that they shall be prefaced by the words answer to the first cause of action, answer to the second cause of action. The body of the pleading also contains the relief or the prayer. Okay, it shall specify the relief sought and also the date of the pleading. The pleading also contains the signature of the party and his counsel. It serves as a certification that he has read the complaint, that it is not a frivolous case, and that they have a meritorious case. It also contains a verification appended at the end of the pleading, signed by the party to attest that the allegations are based on his personal knowledge or authentic records. It is not intended to harass or cause delay, and the factual allegations have evidentiary support. It also contains a certification against forum shopping that he has not commenced any action involving the same issues in any court, tribunal, or quasi-judicial agency, and to the best of his knowledge, no such other action is pending therein, and if there is such pending action, a complete statement of such status, and if he learns that a pending action has been filed or is pending, he shall report such fact within 5 calendar days to the court where his complaint has been filed. Okay. So the signature and address of the counsel constitutes a certificate that he has read the pleading and that to the best of his knowledge, information and belief formed after inquiry under the circumstances. that it is not being presented for any improper purpose, that the claims, defenses, and other legal contentions are warranted by existing law, jurisprudence, the factual contentions have evidentiary support, the denials of factual contentions are warranted on the evidence. If the court determines on motion that this rule has been violated, it may impose an appropriate sanction or refer the violation to the proper office for disciplinary action. So you must remember that lawyers are officers of the court. So when a lawyer files a case, it also, by signing the initiatory pleading, he also certifies or guarantees that it is not a suit uh, filed for the purpose of harassing the opposing party. It is a suit in which he believes to have legal and evidentiary support. Republic versus Kendrick. In this case, Kendrick constructed on a property owned by a people. Kendrick claimed ownership, claiming that that he has a title to the said property. Now, the Solicitor General filed a complaint for revocation of Kendrick's title. Now, the respondent filed its answer, which was purportedly signed by a certain Attorney Garlitos. Now, Attorney Garlitos testified that he prepared the respondent's answer and transmitted an unsigned draft to the president. The signature appearing above his name was not his. So the counsel denied that he signed the said pleading. He authorized no one to sign in his behalf either. So only the signature of either the party himself or his counsel operates to validly convert a pleading from one that is unsigned to one that is signed. The counsel's authority and duty to sign a pleading are personal to him. He may not delegate it to any other person. The signature of counsel constitutes an assurance that he has read the pleading, that to the best of his knowledge, there is good ground to support it, and that it is not interposed for delay. It is counsel alone, by affixing his signature, who can certify to these matters. Respondent's answer was invalid and of no legal effect, as it was an unsigned pleading. Respondent was properly declared in default, and the Republic was rightly allowed to present evidence ex parte. So aside from the counsel's signature, the counsel is likewise required to indicate the following information in his pleading: his address, the roll of attorney's number, his official receipt of the IBP or his lifetime membership, his professional tax receipt number, the MCLE certificate of compliance, the counsel's contact details. Failure to indicate the counsel's correct MCLE compliance would subject him to appropriate penalty and disciplinary action. What are the other mandatory contents of a pleading? They are as follows. Now, under the new rules, it is required that the names of the witnesses who will be presented to prove a party's case must be mentioned. It must also contain a summary of the witnesses' intended testimonies and also the judicial affidavits of the said witnesses. Only the witnesses whose judicial affidavits are attached shall be presented by the parties during the trial. Okay, if you want to present another witness whose judicial affidavit was not attached, he has to ask leave or permission from the court, and he has to present a meritorious reason. Why was it that said witness was not included among the list of witnesses stated in the pleading? Okay. Also, it must contain documentary and object evidence in support of the allegations contained in the pleading. Okay. The purpose of the requirement, why is it that now it is required that the judicial affidavits of the witnesses should be appended to the pleading to avoid unnecessary surprises and aid in the preparation of the parties in the trial. Verification, except when otherwise specifically required by law or rule, pleadings need not be under oath or verified. A pleading is verified by an affidavit of an affiant duly authorized to sign the said verification. Now, the authorization of the affiant, whether in the form of a secretary's certificate or SPA, should be attached to the pleading and shall allege the following: that the allegations in the pleading are true and correct based on his personal knowledge or based on authentic documents. The pleading was not filed to harass, cause delay, or needlessly increase the cost of litigation, and that the factual allegations have evidentiary support or, if specifically so identified, will likewise have evidentiary support after a reasonable opportunity for discovery. So the signature of the affiant shall further serve as a certification of the truthfulness of the allegations in the Republic versus Bernabe. So this is a complaint for cancellation of title and reversion, which was filed by the Republic against Bernabe for a lot registered in her name but is located inside a military reservation. Now, while this case was pending, Bernabe mortgaged the property to CRBB. Now, the OSG filed an amended complaint in pleading CRBB as defendant. The President and Chief CRBB filed a motion to dismiss, arguing that there is no showing that Attorney Casanova was indeed authorized by BCDA Board to sign the documents. The issue is whether the CA erred in affirming the resolution of the RTC dismissing the second amended complaint for reversion and cancellation of title on the ground that the BCDA president cannot sign the recaps. Um, okay. The court reiterating the pronouncement in the case of Altres versus Empleo, reinstated or reiterated the um, result of non-compliance with the requirements of the verification and certification against forum shop. Okay, first, a distinction must be made between non-compliance with the requirements on or submission of defective verification vis-a-vis non-compliance with the requirements on or submission of defective certification against forum shop. As to verification, non-compliance therewith or a defect therein does not necessarily render the pleading fatally defective. The court may order its submission or correction or act on the pleading if the attending circumstances are such that strict compliance with the rules may be dispensed with in order that the ends of justice may be served. Verification is deemed substantially complied with when one who has ample knowledge to swear to the truth of the allegations in the complaint. As to certification against forum shopping, non-compliance or a defect therein is generally not curable by its subsequent submission or correction thereof, unless there is a need to relax the rules on the ground of substantial compliance or presence of special circumstances or compelling reasons. The certification against forum shopping must be signed by all the plaintiffs in the case. Those who did not sign will be dropped as parties to the case. Finally, the certification against forum shopping must be executed by the party pleader, not by his counsel. If, however, for justifiable reasons, the party pleader is unable to sign, he must execute a special power of attorney designating his counsel to sign in his behalf. In this case, the merits of petitioner case should be considered as special circumstances or compelling reasons that justify tempering the requirement in regard to the certificate of non-forum shopping. Petitioner herein did submit a certification, failing only to show proof that the signatory was authorized to do so. That petitioner subsequently submitted a secretary's certificate attesting that he was authorized to file an action on behalf of the petitioner, likewise mitigates this oversight. Coruga versus Arsenas. So in this case, Coruga is a minority stockholder of Bangko Pilipino. He filed a complaint before Makati RTC for violation of the corporation code. Arsenas alleged that the verification and certification against forum shopping attached in the petition was not executed in the manner prescribed by law as admitted by Coruga's counsel because the same was only a facsimile. So petitioner is currently in the United States and the counsel attached a facsimile copy of the verification and certification of non-forum shop. Okay. Petitioner submitted the original copy of the duly notarized and authenticated verification and certification that she executed, and the court considered the compliance as satisfactory. We have the case of Ochoa versus Dobuco. Okay. With respect to the lack of signatures of certain senators in the petition, it found substantial compliance in the signatures of just two of the petitioners in the verification, considering that they were unquestionably real parties in interest who undoubtedly have sufficient knowledge and belief to swear to the truth of the allegations in the petition. The same rule was applied, and the court decreed that the signing by only one of the 22 petitioners in the certification is substantial compliance. Applying these principles to this case, the signature of Ochoa acting on behalf of the Office of the President in the verification and certification is sufficient substantial compliance, taking into account their common interest in the exercise of their disciplining authority over erring government officials. But the general rule is all of the plaintiffs or all of the petitioners must sign the verification and certification against forum shop. We have the case of Pil Estate Properties versus Reyes. The provision was intended to cover only initiatory pleading. So, where do you attach the verification and certification against forum shopping? So, it applies to complaints. Does it apply to answer? Yes, because if there is a counterclaim, especially if it is a permissive counterclaim, okay, it should also contain a verification and certification against forum shopping. Okay. A claim for it is intended to cover initiatory pleadings asserting a claim or relief. A claim or relief that is derived only from or is necessarily connected with the main action, such as an answer with compulsory counterclaim, is not covered by the rule requiring a certification against forum shopping. A comment to the petition filed before the appellate tribunal, not being an initiatory pleading, does not require a certification against forum shopping. Forum shopping exists when litigants resort to two different forums for the purpose of obtaining the same relief to increase the chances of obtaining a favorable judgment. So the evil sought to be avoided by the rule on forum shopping is arriving at contrary decisions of the same controversy. There is forum shopping when the elements of litis pendentia or res judicata are present. Okay, there is forum shopping when the following elements are present: identity of parties, or at least such parties as represent the same interests in both action, identity of rights asserted and reliefs prayed for, identity of the two preceding particulars such that any judgment rendered in the other action will, regardless of which party is successful, amount to res judicata. So it may seem that Reyes committed forum shopping by elevating Agrarian Reform Secretary's adverse order to the office of the President, then filing a petition to reopen the case before the Secretary of Agrarian Reform. Dinglasan versus Ayala Corporation. This was previously discussed already relative to the distinction between verification and certification against forum shopping. So in this case, there was sufficient basis for Sonia to speak for and in behalf of his co-petitioners when she certified that they had not filed an action in another court involving the same issues. Thus, the verification that Sonia executed constitutes substantial compliance. The court held that where the petitioners are immediate relatives who share a common interest in the property subject of the action, the fact that only one of the petitioners executed the verification certification will not deter the court from proceeding with the action. You must remember that with respect to certification against forum shopping, non-compliance with the requirements cannot be cured by amendment of the complaint or the initiatory pleading. So non-compliance will result in the dismissal of the complaint upon motion after hearing. Okay. Submission of false certification or non-compliance with any of the undertakings shall constitute indirect contempt of court. Willful and deliberate forum shopping is a ground for summary dismissal and constitutes direct contempt. An answer with a permissive counterclaim, a cross-claim, a third or fourth party complaint, and a complaint in intervention are initiatory pleadings and therefore require certification. Rojas versus Court of Appeals. In this case, the proceedings or orders issued by the judge in the application for support pendente lite in the refiled case was rendered null and void by the omission of a statement in the certificate of non-forum shopping regarding the prior filing and dismissal without prejudice of the first case, which involves the same parties and issues. It is primarily intended to cover an initiatory pleading or an incipient application of a party asserting a claim for relief. The most important factor to determine the existence of forum shopping is the vexation caused the courts and party litigants by a party who asks different courts to rule on the same or related causes. Since a party resorts to forum shopping to increase his chances for a favorable decision, a party cannot be said to have sought to improve his chances of obtaining a favorable decision when no unfavorable decision was rendered in a case he has brought before the court. There was no adverse decision in the first case, considering that it was done before service of answer or of any responsive pleading. The dismissal does not amount to litis pendentia nor to res judicata. There is no litis pendentia since the first case was dismissed or withdrawn by the plaintiff without prejudice upon her filing of a notice of dismissal. To use the wording of that rule, the judge order is one merely confirming the dismissal of the complaint. Neither is there res judicata for the reason that the order of dismissal was not a decision on the merits but a dismissal without prejudice. A liberal interpretation on the rules of forum shopping would be more in keeping with the objective of procedural rules, which is to secure a just, speedy, and inexpensive disposition of every action. So that is all for pleadings. Thank you for listening and don't forget to subscribe. The court held that where the petitioners are immediate relatives who share a common interest in the property subject of the action, the fact that only one of the petitioners executed the verification certification will not deter the court from proceeding with the action. You must remember that with respect to certification against forum shopping, non-compliance with the requirements cannot be cured by amendment of the complaint or the initiatory pleading. So non-compliance will result in the dismissal of the complaint upon motion after hearing. Okay. Submission of false certification or non-compliance with any of the undertakings shall constitute indirect contempt of court. Willful and deliberate forum shopping is a ground for summary dismissal and constitutes direct contempt. An answer with a permissive counterclaim, a cross-claim, a third or fourth party complaint, and a complaint in intervention are initiatory pleadings and therefore require certification. Rojas versus Court of Appeals. In this case, the proceedings or orders issued by the judge in the application for support pendente lite in the refiled case was rendered null and void by the omission of a statement in the certificate of non-forum shopping regarding the prior filing and dismissal without prejudice of the first case, which involves the same parties and issues. It is primarily intended to cover an initiatory pleading or an incipient application of a party asserting a claim for relief. The most important factor to determine the existence of forum shopping is the vexation caused the courts and party litigants by a party who asks different courts to rule on the same or related causes. Since a party resorts to forum shopping to increase his chances for a favorable decision, a party cannot be said to have sought to improve his chances of obtaining a favorable decision when no unfavorable decision was rendered in a case he has brought before the court. There was no adverse decision in the first case, considering that it was done before service of answer or of any responsive pleading. The dismissal does not amount to litis pendentia nor to res judicata. There is no litis pendentia since the first case was dismissed or withdrawn by the plaintiff without prejudice upon her filing of a notice of dismissal. To use the wording of that rule, the judge order is one merely confirming the dismissal of the complaint. Neither is there res judicata for the reason that the order of dismissal was not a decision on the merits but a dismissal without prejudice. A liberal interpretation on the rules of forum shopping would be more in keeping with the objective of procedural rules, which is to secure a just, speedy, and inexpensive disposition of every action. So that is all for pleadings. Thank you for listening and don't forget to subscribe.